person statute.
Correct. I had a bunch of emails because the Hēmāni case, Thomas and the Commerce Clause and his concurrence. I'm going to take a deep dive into that and tell you what I think Thomas is up to here.
All right.
Just after, because I started reading this and started studying this a little bit more, I found his concurrence interesting because he seemed to deviate. Why? What was he doing? Well, we're going to try to answer that question for you today because, trust me, when it comes to your gun rights, Thomas doesn't play games. There is always, always a method to his madness. But I think the first place to start is, and I got at least 50 emails across 3 different platforms. What is 922G or G3? Can you explain that? You guys keep talking about it. And I want to apologize in advance because we do know that stuff, and sometimes we don't explain it, right? It's part of our lexicon. It's part of our vernacular, and we tend not to. I went back and I looked at some of my conversation with Jared Yanis, and we were referencing specifically 922G3 a number of times without really explaining what it is. U.S. Code 18, it's 18 U.S. Code 922G. It's the federal statute or federal law that makes it unlawful for specific high-risk categories of people to either ship, transport, possess, or receive a firearm and or ammunition. Commonly known, we commonly refer to it as what? The felon in possession, right? Statute. Yep. Is basically what it's referred to as, but it goes a lot deeper than that. And this is where Thomas went really off the rails here, and I'm going to take a dive into that because I think it's very important going forward. And these matters to you, ladies and gentlemen, for a number of different reasons. I'll take a dive into that and explain why in just a few moments. But, these penalties can put you in prison for 10 years and beyond. And that's not a place you want to be. So what are the categories of the prohibited persons that the statute includes? Convicted felons. Anyone convicted of a crime punishable by a term or imprisonment exceeding 1 year. Fugitives, right? Every time I hear that word, I think of the movie. And I don't know why, because I've only seen the movie once, The Fugitive. Individuals fleeing from any state to avoid prosecution. You're on the lam, right? You're on the run. You're a fugitive from justice. This applies to you. Controlled substance users. Now, ladies and gentlemen, look at 922, we refer to 922G3. 922G1 is convicted felons. 922G2 is fugitives. 922G3 is controlled substance users. And that category, unlawful users of or addicts to any or of any controlled substance. Now, Greg, will there be changes to this? As a result of Hēmāni, okay?
Yep. Think there might?
Well, the basic question changes to the Form 4473. And guys, for those of you who might be new to the program, of course, the Hēmāni case is the landmark ruling that came down a couple days ago from the Supreme Court. And that was, it as the weed and guns law. And we'll get into that. I want to talk about some of those headlines and why Thomas moved in a different direction. I found it fascinating the more I read into it and studied it. And having read so much of what Thomas has written, I have a pretty good idea of what I think he was doing. But number 4 is mental health adjudications. Okay, if you've been adjudicated mentally defective for whatever purpose, or maybe you've been formally committed to a mental institution, this applies. Unlawful non-citizens. First off, what's a lawful non-citizen? Permanent resident, who is here legally with permanent resident status. Unlawful non-citizens are persons who are illegally present or unlawfully in the United States. Think Biden voters, okay? And those admitted under specific, there's different categories, specific non-immigrant visas. And I happen to know a lot about that because my former wife in a life in a galaxy far, far away was brought here from Sweden under the fiancé laws and the immigration status, and I was very, very intimately familiar with how all of that worked. Military discharge matters. If you've been dishonorably discharged from the armed forces, this applies to you. If you've renounced your citizenship, anyone who has renounced their citizenship, say that fast, to the United States ever, this applies to you. Domestic violence restraining orders. Now, I know this one always gets to Greg and myself as well. Yeah, we can go down a bunch of different rabbit holes, Lautenberg, and we're not going to do that. Just I'm going to mention to it because it's here. Domestic violence restraining orders, individuals that are subject to a court order or a restraining order to keep you or that person from harassing, hassling, stalking, you know the routine, or threatening an intimate partner or a child. And then, of course, domestic violence convictions, anyone convicted of misdemeanor crime, Greg, of domestic violence. There comes Lautenberg, okay? That's that whole Lautenberg deal. The law requires, under 922G3, keep in mind what just happened in Hēmāni. And we'll go into more details about that coming up in the next 3 segments. But the law requires the government to have to prove beyond a reasonable doubt that the individual knowingly possessed the firearm or ammunition, and that the item traveled in or affected interstate commerce. This commerce clause has been abused by the federal government, ladies and gentlemen, forever. Because anything can be considered commerce. And that's just a tease of where I think Thomas was going. What are firearms, Greg? Firearms are a constitutionally protected tool. We have a right to keep and bear arms. And this is where Thomas was going after I read this at least 5 or 6 times. And it's funny because every time I read it, and I would highly encourage you, ladies and gentlemen, to read Thomas's concurrence. You can find it at supremecourt.gov. Just look under opinions of the court and click on Hēmāni and read the entire thing. All of these opinions are amazing, particularly when it comes to our Second Amendment rights. But nonetheless, the concurrences don't carry the weight of the opinion. It's simply the justice making some points. And boy, did Thomas make some points after a really good, solid read. Now, the provisions that we talk about here that we hear on this program all the time is 922G3. Okay? And the key elements of that provision, of course, are to drugs restricted under the Federal Controlled Substance Act. Now, marijuana the schedule has changed. The Hēmāni case is over. It was deemed that the government cannot determine you to be a dangerous person simply because you're a user of one of these drugs. Does not make you, in this point, cannabis, weed, ganja, 420. You know the routine. Been talking about it for a couple weeks, or well, in large measure the last few days because the case was just released, the decision was just released. But nonetheless, because marijuana remains, this is the key, federally illegal, at least for now, okay? And the statute has historically applied to all cannabis users. And I was kind of shocked that I got a lot of questions about that. But it applied to everybody, which is why we'd always put the warning out. If you have a medical marijuana card, if you smoke weed at all, and you answer blank on the 4473, no, you're committing a federal charge of perjury. You are lying on the 4473. All of that's going to change. Now, when we come back from the break, and the penalties for that too, guys, can be stiff. 10 to 15 years in a slammer, okay, in a federal penitentiary. And that would, the length of that would depend on any previous criminal convictions or record you may have had. Maybe when you were a kid, over 18 at least, that has not been expunged. All of this matters. So when we come back, I'll break down the application for the 2026 ruling in Hēmāni, and then I'm going to try to get into Thomas's head, which might not be a smart thing to do because he's far smarter than I am, but I'm going to give it a whack for the next 3 segments, and we'll see what we can come up with. We'll see what we can conjure up here in the Armed American CZ Firearms Studios in front of this Patriot Mobile. Mike got the Patriot Mobile Ranch for you. We'll be right back. Make sure to check them out. So let's go back into this 922G3. Why does this matter? Because this is what allows the federal government to make a federal case out of you if you fall into one of these categories. In this case, Hēmāni fell into 922G3. And I think that in and of itself, Greg, just answered a lot of questions for a lot of people who were saying, what is this? And I guess my initial response is Google. It's right there for you.
It'll explain it out right there.
But what it doesn't do is it doesn't give you the nuance and the particulars that we're going to go into here and why Thomas felt this was so important. Because I think we have to start with this. And that is, in order to break down Thomas, at least in my mind, and I'm going to give you about 4 different points where I think Thomas was going here that I've kind of drawn a conclusion on. And I could be wrong, but hard to get in somebody's head. But to understand Thomas's point, it really helps to separate commerce in the terms of what everybody agrees Congress can regulate, okay, from what Thomas argues may exceed Congress's authority to do so, all right? Here's where, when it comes to guns, I think everybody's in agreement, including Thomas, where guns are part of interstate commerce. Because Congress unquestionably has the authority, constitutional authority, to regulate activities such as this. We'll relate it to firearms, manufacturing firearms for interstate sale, shipping firearms across state lines. Only Congress possesses this commerce authority, which is why it's so ripe for abuse, by the way, ladies and gentlemen. You've probably figured that out. Licensed firearms dealers engaged in interstate commerce, importing and exporting firearms, interstate sales and transfers, interstate transportation by commercial carriers. Well, if a gun is made by Glock in Smyrna, Georgia, just minutes, stone's throw from me right here, and it is shipped to you in Texas, Greg, okay, clearly that's interstate transportation of commerce. So these are basically classic examples of commerce among the states. Let me phrase it that way. Thomas doesn't question that. He didn't question that at all. But he did mention where he feels some problems begin, and that's why he laid this out. Because while it allowed the government to prosecute Hēmāni to begin with, it wasn't brought up in the case because it wasn't a commerce case. Do you see the disconnect there, Greg? To me, that seems like it just seems like a weird disconnect to me. But I'm not a lawyer. But do you see where I'm going with that? It's kind of strange.
I think so, yeah.
So Thomas argues that once commerce ends, once interstate commerce ends, Congress's authority is far less clear than it is under the categories that I just mentioned to you. For example, let's go back to Georgia again. A manufacturer in Georgia builds a pistol. That pistol is shipped to a distributor in Texas, Greg, and a Texas dealer sells it to you. You keep it in your Texas home for 15, 20 years. Nothing else involving interstate commerce ever happens again. So Thomas asks the question, is that still interstate commerce? Why is the government able to prosecute something after the commerce aspect is done? Because it was done in the past. This gets a little bit abstract here, guys, okay? But try to walk with me here because I feel you. I'm trying to do the best I can to explain this to you. And Thomas's short answer is, this is not commerce anymore. At that point, the gun that was made in Georgia, that was shipped to Texas to a dealer, that was sold to Greg and sat in his house for 20 years, is merely possessed, simple private property that you possess entirely within one state, period. Now, why does this matter under 922G? Again, because today, federal prosecutors often prove the Commerce Clause element by showing only one thing, ladies and gentlemen, that the firearm was manufactured in another state. That's it. And that's enough because the firearm necessarily crossed state lines at some point, even though it may never have again. And what Thomas is doing in an overarching view in his concurrence is he's questioning whether the historical fact, that historical fact of that firearm itself, is sufficient enough to somehow justify federal regulation of your possession later in life. So that's where that disconnect comes from. So in that case, everything. And Greg, you know, I was in the transportation business for well over 20 years. You know that. I ran a brokerage company, a consulting company. And prior to that, when I got out of college, right after I got out of college, I went to work selling for motor carriers. And I had a lot of fun doing it. It eventually led to a couple successful businesses, and I got sick of the transportation industry and didn't want anything to do with it anymore. Once it became no fun, I left. But I understand how this works as a result, okay? So when you look at when or how the gun was made, and because it necessarily crossed state lines at some point, and Thomas's factual question, which is true, if it's insufficient to justify federal regulation of your possession later down the road. Is it, Greg? Because, look, here's the statement I was going to make. Let me go back on that before I get lost here because I've got so many notes. But having been in transportation all these years, and I can say this to you 100% honestly, ladies and gentlemen, I can look you dead in your eye and say, every single thing your eyeball can see or your fingers can touch has at some point, in whole or in part, been on the back of a motor carrier moving to or from somewhere. Either it's
30.
individual parts, it's assembled part, it's all been on a truck. Everything is my point. Everything can be considered commerce. And boy, does the government have a whole lot of power there. Yeah, they've wielded it many, many, many times over. Thomas is looking at this is where we're going to go in the next two segments, as a huge threat down the road, maybe. I don't think he's looking more towards future cases. He's asking the court to begin to revisit this as it pertains to firearms in the future as a result of this. So that's why he got out of the guardrails. When we come back, I'm going to do my level best to try to break down what I think
20.
he meant by all of this and why it matters to every single American that's a gun owner now or will be. Even if you're not, it matters because, well, everything's commerce, right? We'll be right back. All right, so now we're going to get into why I think Thomas did what he did and why he felt it necessary to write a multi-page concurring opinion focusing essentially specifically on this, okay? Now, again, I pointed out where I thought Thomas believes, what I think where he believes the problem starts, and that's once interstate commerce ends, Congress's authority becomes very, very muddy at that point. And I use the example of the pistol in Georgia sent to Greg in Texas, et cetera. Okay, so I closed with that when I was talking about that was simply that the gun is simply private property at that point. That's where Thomas is alluding. And it's possessed entirely within one state. Now, as I got to thinking about that during the break, Greg, this is where my mind goes in a bunch of different directions. I got to thinking about, Tennessee's a great example. Hey, we're going to make sure in our state that the government can't come after us from a commerce standpoint if every single part of this gun in particular is made here, or accessory, think suppressor, okay, is made here within this state. There is no interstate commerce. Boom, that knocks out the federal government. The problem is the federal government still regulates those items under the NFA, and many people who actually fell for that, to be frank, bought that stuff. There are people sitting in prison as a result of that for violating federal law of possession of something that the government, commerce or not, claimed was unlawful to own. So you need to be very careful there. But there is this weird tie in there, okay? Here's why it matters, because prosecutors claim and use the commerce clause to prove, or show anyway, that the firearm was in fact manufactured in another state. And as I said, that's enough because it simply crossed state lines. What Thomas did in his opinion is he relied on several categories from the United States v. Lopez case. And let me break this down here and why Thomas felt that was important. Because Lopez says that Congress may regulate, number one, the channels of interstate commerce. And these are the routes commerce travels: highways, railroads, shipping routes, airplanes. Congress can therefore regulate firearms moving through these channels, gives them carte blanche. Number two, what are the instrumentalities of interstate commerce? And these are things, or the people that are actually engaged in interstate commerce. Think commercial trucks, the equipment itself, drivers, freight trains, okay? Union Pacific Railroad, whoever it may be, cargo aircraft, FedEx, UPS, a motor carrier, whatever it may be, and all other interstate shipments. Congress can protect and regulate all of the above, and they do. And number three in Lopez that he pointed out was activities that substantially affect interstate commerce. And that's a very broad category, admittedly. And that's where the government can go off in a bunch of different directions, and has. But Congress can regulate economic activities in the whole, in the aggregate, in the sum, that substantially affect interstate commerce. And examples of that were pointed out as commercial agriculture, national commodity markets, things of this nature, interstate business transactions. And what Thomas is arguing is that mere possession of a firearm inside one state is not an economic activity, and therefore, flat out, does not fit this category, period. And he's got a central point to this that I think is worth repeating, because he repeatedly emphasized that possession is different from commerce. He said, buying a gun, commerce. Selling a gun, commerce. Shipping a gun, commerce. Manufacturing a gun, commerce. Possession of your own gun in your own house years later, that's not commerce. Nah, I don't think so, dog. That's possession. Now we have a prohibited person in possession of a gun that the federal government had just blanketed as dangerous because of the possession of the drug and the gun at the same time, which has been wiped out from the Hēmāni case. So this is where Thomas started to go down some rails. Suppose, an example, suppose you buy a refrigerator made in Ohio. It gets shipped to your home in Texas 20 years later. It's still in your kitchen. Would anyone seriously argue that that refrigerator is still engaged in interstate commerce? Not without laughing, because it's where it's supposed to be. So the answer to that is, of course not. Thomas says a firearm should be analyzed the exact same way. Once interstate commerce ends, simple possession inside one state falls outside Congress's Commerce Clause authority, and he says may fall outside, which is his invitation for a future case. So if I had to rank all of Thomas's concerns, I would say that the first rank I would give would be that current courts, according to Thomas, have completely misinterpreted the Constitution. All right? Because he repeatedly criticized the lower federal courts, not Congress, the courts, for how they've interpreted 922G, saying that they've made two fundamental mistakes here over the years. They've treated Scarborough v. United States as though it decided the constitutional question when it only interpreted the statute. Not enough time to go into there, but trust me, that's what Scarborough did. And they've assumed, meaning the courts, that a minimal jurisdictional hook, meaning the gun once crossed state lines, automatically makes the statute constitutional. And he spent several pages explaining why he believes these courts got it wrong. In fact, he references 4 cases. Okay? But what that tells me Thomas is doing, and I could be way off here, but I don't think I am, having read it multiple times, is he is targeting judicial doctrine or precedent that has developed over many, many decades in his concurrence. He's inviting future challenges to this, and this case gave him the opportunity to do it simply because there's a connection between prosecution at the federal level using the Interstate Commerce Clause to even bring a charge, which is why he did it. He's brilliant. I'm glad he did it. It's going to play out over time, and it's going to be fascinating to watch, but we're talking years down the road here. This is not a question. This is Thomas basically saying, hey, in a galaxy far away from now, when I'm no longer here, this needs to be revisited. Congress's power is way too broad.
30.
Now, on the short end of this, could Thomas have been saying, we don't want another anti-gun administration to be able to come in here and Congress write laws or changes to commerce that affect firearms as another way to ban possession in a way that we might not think of yet today? I would say, knowing Thomas and understanding him over the years, likely yes, but I don't think that was the main point. I don't think he was looking more, I think he was looking more at court doctrine and how it's currently being interpreted over the previous few years and what has to happen going forward. I'll give you his third concern when we come back, and I'll try to break it down in just a general, I'll summarize what I think his concern is on all of this, because it does get a little complicated, but it is fascinating. We'll be back. We have one more segment to go on a garbage day here at the ranch. Don't go away. Is Thomas signaling something about a future Congress? Yeah, I think he is, but I think he was doing it indirectly. I don't think that was his main focus. His warning isn't Congress might someday pass terrible laws, although it kind of is. That was not his main focus. I think he's, tell me that without telling me that. What he's warning, in my estimation, is that if courts continue reading the Commerce Clause as broadly as they currently are, Congress will continue exercising powers that the Constitution has never given it. And that's what this is all about. Because remember, the Constitution and our Bill of Rights was designed to do what? Keep a check on federal government, not us, on the government. And that's a critical distinction here. Thomas's main concerns are about constitutional boundaries. That's what he's talking about here, and that's why Hēmāni gave him the opportunity to do that. So if I was going to summarize for you his concern, I would say that he's not sounding an alarm about what future Congress might do tomorrow. He's sounding the alarm about what the courts have already allowed Congress to get away with. His message here, I believe, is that federal judges have allowed, by stretching the government to stretch the Commerce Clause so far, that Congress itself can now regulate conduct that looks absolutely nothing like interstate commerce. He believes it's the judiciary's responsibility, in that judicial doctrine I talked about, precedent that he's looking at. It's the judicial responsibility, judiciary's responsibility, to restore the Constitution's original limits. He's an originalist. That's what I love about him. And I think, at least in my estimation, that's the most accurate reading that I can come up with on his concurrence. He's not trying to primarily influence future legislation as much as he's urging the judiciary to reconsider decades of Commerce Clause jurisprudence precedent and enforce what he sees as the Constitution's existing limits, period. That's what I think he's doing. And he made that very clear. And an interesting question is, why this case to bring this up? Well, I came up with about 4 different ideas. But it was a natural fit for him to do it because the Hēmāni case actually presented him a pretty solid vehicle to bring this issue up, because the Hēmāni case was about 922G3, one of the provisions of the prohibited persons provision. In 922G in total, it was 922G3. So to prosecute Hēmāni federally, the government relied on that jurisdictional element that the firearm had previously traveled. That's what gives them the authority. That's what gave them the authority to prosecute, period. He points out that the government didn't have to prove Hēmāni crossed state lines or engaged in interstate commerce. Now, that didn't come up in the case. It only had to prove the gun had done so sometime in the past. But it allowed him the opportunity to say this: we're talking about the Second Amendment today, but there's another constitutional question nobody has asked us to decide. And that's how he begins with his concurrence. He agrees with the court, the majority opinion, of course, then says he's writing separately to call attention to another issue. So what he's doing, the second thing I think he's doing is he's signaling to future litigants. And personally, I think that's the strongest explanation for what he's got going on here. He repeatedly says the Commerce Clause wasn't presented in Hēmāni. He reminds us that. He doesn't decide it. Instead, he ends by saying, this question merits a closer look in an appropriate case. Because you have to look at, what do the Supreme Court justices do in their concurrences? Why do they write these opinions? We talked about Ketanji Brown. She was signaling, while I respect Bruin's precedent, if I ever get an opportunity, I'm going to wipe out Bruin, with that big but in there that she literally put at the top of her concurring opinion. And justices usually use concurrences to identify some type of legal issue important to them that wasn't necessarily before the court in a particular case, but they believe might deserve future review. And that is essentially what Thomas said. It's not an order to a lower court. It's just a signal to lawyers, potential litigants, and judges. If you bring the right case, I want to hear it, is kind of what he's saying here. And number 3, I think, is that he sees the Commerce Clause limits as the next constitutional frontier. I do believe that, based on how much time he spent here. Because Thomas is an originalist. He gets it. We understand the Constitution based at the time it was written and what it meant then. And we adopt it or adapt it to today. And it has worked for 250 years. We still debate it every single day. But it's still the best document written in the world. And Hēmāni, I believe, gave him a chance to remind the legal community out there, of which he is a part of course, that entire community, that the Commerce Clause itself actually should impose more or real limits on federal power. I don't know if I articulated that properly. I hope I did. And I think he wants to see, to close out, two separate constitutional questions answered, because most litigation over 922G in recent years has focused on the Second Amendment, especially after Bruin. And he appears to be saying, even if you lose under the Second Amendment, or even if you win, there's another constitutional question at stake here that deserves independent attention. In other words, he doesn't want every challenge to 922G to be viewed strictly through the lens of the Second Amendment. He's reminding the courts that Congress's enumerated powers under Article 1 are, in fact, a separate constitutional inquiry. And that's, I believe, where he's going with this and why he used Hēmāni as the vehicle to do so. A deep dive, it's complicated, I know, and every time I look at it, I can concoct something else in here. But nonetheless, the best thing you can do is read it for yourself, come up with your own conclusions, maybe use this as a guideline. Tell me I'm right, tell me I'm wrong. If you're watching the streams, let me know in the comments. Guys, we're going to do it again tomorrow. Enjoy your day. Stay safe. See you on the radio. Thanks for being here.